explain about negligent misstatement. First, we start with the definition. The definition of negligent misstatement is a false statement made by a party honestly but it is inaccurate or misleading. A person may be held liable for statements made where reasonable reliance on that statement give rise to foreseeable financial loss for the party relying on the statement. It is only actionable if there has been breach of duty to take care in providing the statement that has caused damage to the claimant. Basically, negligent misstatement is a topic under economic loss in negligence. In the case of Caparo Industry against Dickman and others, 1990, the House of Lords held that no duty of care arises in this case and the defendant was found not liable. In this case, lack of proximity between the auditor and the member of the public results to unlimited liability on the part of the auditor. There are three criteria to prove duty of care in this case, which is possibility of damage, proximity of relationship, and reasonableness. In order to prove whether the liability arises for false statement, court went on examine the principle. When there's a special relationship between plaintiff and defendants, the duty of care may be arise. Thus, the duty of care arises when there are special relationship between defendant and plaintiff, and it was determined by three factors, which is the plaintiff believe and relies on the defendant's information or advice. Secondly, the defendants know and ought reasonably to know that the inquirer or plaintiff believe and relies on his information or advice. And thirdly, it is reasonable in the circumstances for the inquirer or plaintiff to believe or rely on the defendant's information or advice. In the case of Hadley, Bain and Co. against Hallett and Partner Limited, the House of Lords held that the defendant banked by the word which they employed and had effectively disclaimed any assumption of a duty of care. They already avoid any duty of care on their behalf and they are not liable to the plaintiff by the disclaimer in the letter. Disclaimer literally means a formal statement saying that you are not legally responsible for something such as the information in a book or on the internet, or that you have no direct involvement in it.
A duty of care will arise when the special relationship between plaintiff and defendant exists, which are determinable by three factors. The first factor is the plaintiff relies on defendant advice or information. The second factor is the defendants know or ought to reasonably know that plaintiff relies on their advice. The third factor is it is reasonable in the circumstances for plaintiff to do so. In this case, Smith and Eric S. Bosch, the plaintiff applied to the building society for a mortgage to assist her on purchasing a house. The building society had instructed the defendant, a firm of surveyor and valuer, to prepare a report regarding the condition of the house, and they stated that there was nothing essentially wrong with the house which was wrong, as the chimney collapsed and broke through the roofs. Furthermore, the plaintiff and defendant did not have a contract between them because the plaintiff applied through building society and building society hired the defendant. And there was even an exemption clause which excused the defendant from his responsibility to prepare the right contract. Next slide. The court held that the exemption clause was unreasonable in according to Unfair Contract Terms Act in 1977. It was common practice for the purchaser to rely on the report prepared by them. Hence, in this case, the special relationship between plaintiff and defendant exists as plaintiff relied on defendant's advice before buying the house. Hence, in this case, special relationship between plaintiff and defendant exists as plaintiff relied on defendant's report before buying the house, and the defendant knows that plaintiff relies on his report because it was common practice there. And lastly, it is reasonable for plaintiff to do that because defendant was hired by the building society to prepare a report, and he works in a legal firm of surveyors and valuers. And so an exemption clause was made to protect the defendant from his wrongs, that the exemption clause was not able to protect the defendants from his negligence, as it was deemed unreasonable.
Now we're going to discuss about the other principles in this question. I found the three principles in this question, and one of them is the negligent misstatement. If the plaintiff is able to show a special relationship between the defendant, that he or she that has placed trust and reliance in the defendant's statement, then the defendant may be liable to the economic loss that has been suffered by the plaintiff. For the second principle, if both of the parties are equally knowledgeable, a plaintiff should seek his own independent advice and entirely depending on defendant advice. And for the third principle, a court may also take consideration that even though the defendant is not in the business of giving advice, but he has special and expert knowledge in a particular field. So let us move on to the facts. The facts are collected from these two cases, SO Petroleum versus Madan and Mutual Life and Citizens Assurance versus Event. For the first case, we can see SO give advice regarding the expert of number of annual petrol trade to Mr. Madan. However, Mr. Madan's new filling station fails to achieve the expert number given by SO because of the rerouting of the highway. This causes Mr. Madan to suffer economic loss, and this shows that the SO Petroleum Company is liable on the loss suffered by Mr. Madan. For the second case, the plaintiff can't claim the economic loss caused by the negligent misstatement to the defendant because the defendant was an insurance company. Although they give an advice, but the financial advice they given was not in their professional. So in majority decision, the Privy Council found the defendant is not liable as it was not in the business of giving advice, and it therefore owed duty that there was no duty of care to the plaintiff. So now let us relate these facts to our question, and this indicates that Doubledeal have a special knowledge in investment field. This made Harry to believe and rely on Doubledeal information and advice. This also provides us in the information Doubledeal reasonably know that Harry's belief and relies on his information or advice. It is reasonable in these circumstances for Harry to believe and rely on Doubledeal's information and advice. This has caused him to suffer economic loss. Other than that, Harry clearly has his doubt in investment. He was also facing tax problem. It showed that Harry has not acquired enough knowledge as Doubledeal and pursue them to get advice from Doubledeal. This also has made Harry to suffer economic loss.
Breach of duty of care. Definition of breach of duty is defendant who owes duty of care to plaintiff has acted below the minimum standard of care required by him and caused the plaintiff to suffer harm. There are three requirements to prove breach of duty for Harry to claim Doubledeal Company for negligence. First, proximity. Second, foreseeable of harm. And third one, reasonable reliance. Proximity means the party must be sufficiently close so that it's reasonable foreseeable that one party's negligence would cause loss or damage to the other. Foreseeability of harm, we need to look at both elements from neighborhood principle. Third requirement is reasonable reliance. Reasonable reliance is important for court to see whether defendant know that plaintiff would rely and believe on his advice in such circumstances, and impromptu advice does not give rise to duty of care. Thus, knowledge of part of the defendant that plaintiff is relying on his advice is sufficient to give rise to special relationship. In Spartan Steel and Alloy against Martin Co., the defendants were responsible for digging up a road outside the plaintiff's smelting factory. As a result of their negligence when carrying out this task, they accidentally severed a power supply under the road and caused a
loss of power to plaintiff factory. The consequences, plaintiff suffer financial loss. The court held the defendant was liable for cost of the failure of electric, but not liable for physical damage that is expected to be happen because it is too remote or outside the scope of defendant duty of care. In Spring against Guardian Insurance, the plaintiff was fired from his company as sales representative. While seeking for a new job, he received an unfavorable reference, said he was dishonest from the defendant, which is his ex-employer, and the consequence, the plaintiff did not get a new job. The court found that the defendant is liable because employee owes a duty of care to employees. He should write a reference with a care because he knows that another company will rely on the reference to accept plaintiff for work. The unfavorable reference may lead to financial difficulties to plaintiff.
Next is application. Now, in Harry's case, negligent misstatement plays a vital role in validating Harry's claim against Doubledeal. Now, negligent misstatement is a false statement that made in honesty but carelessly, in which would result in causing damages to its client. Now, in order to establish negligent misstatement, one must have special relationship. This can be seen in the case of Walsh and Jones, whereas the special relationship is established due to the fact that Walsh is John's client. Now, in this case, Harry is Doubledeal's client, in which Doubledeal offers service to give consultation to Harry regarding his financial management. Next is principle in Hadley-Brine. This principle is important to establish negligent misstatement. The principle consists of the plaintiff must believe and rely on the defendant's information or advice. Then the defendant must know and would reasonably assume that the plaintiff would believe and rely on his information. And thirdly is that the circumstances is reasonable enough to assume that the plaintiff would rely and believe the defendant's advice. Now, this can clearly be seen as Harry had went out his way to seek advice from Doubledeal. So, there we could see that Harry does believe and rely on Doubledeal's advice, and Doubledeal knows this due to the fact that he had made Harry his client. And the circumstances in which Harry is Doubledeal's client is reasonable enough to assume that Harry believes that Doubledeal's advice. Next is the principles that closely relate to this case is that the one that gives advice must be in business of giving advice, and this can be proven due to the fact that Doubledeal is in business of giving advice, in which he is managing a service of tax consultation. And lastly is the requirements of duty of care. Firstly, proximity of relationship. This has been solidified due to the fact that Harry is Doubledeal's client. And secondly, forcibility of harm, in which Doubledeal would be reasonably enough to realize that his advice would actually play a vital role in Harry's financial status, and his misconduct of giving advice would eventually lead to harm in Harry's finance. And thirdly is reasonable reliance, and it is safe to assume that Harry relies a lot on Doubledeal's advice. Now, all of these requirements are all fulfilled. And to conclude our presentation, we advise Harry to sue against Doubledeal, as it is clear that Doubledeal is in fact liable and Harry is entitled to claim against Doubledeal for his economic loss.